Good afternoon. Oh yes, now afternoon. I'm David Thomson, as you can see from the glorious picture, and Francesca and Neil with the more glamorous picture. It's also giving the seminar today.
Shortchanged.
No, rubbish. You're great. You're great. Don't let anybody get told otherwise. This is the first in two seminars about limitation. This essentially is focusing on the brass tacks of limitation, section 11, section 14. Francesca's doing the interesting part about the dates of knowledge, section 14. And then once we've outlined some of the relevant case law and any necessary updates, we're then going to look at the thrust of it is, what's to be done from a claimant's point of view to make sure that you can comply with 11 and 14. And from the defendant's point of view, is there anything that can be done to improve one's limitation defences? The big problem with a good deal of these, as you'll see from the next seminar or webinar that's coming along on section 33, is that claimants have a tremendous amount of success with section 33, and it's almost the ace up your sleeve for the moment. But we'll dwell on that in due course in the next webinar. There are other issues to highlight here today. So just go on to the next slide, if you would. Working? Yes. This is just the summary of the limitation is in the previous briefing, and there's the hyperlink to that, or the web link to it. There's also a summary with that as part of the briefing or accompanying the briefing that provides the details, the relevant parts of the Limitation Act, etc. So those are there. I haven't attached them to this presentation. You can just go and look at those and have a look. There's a summary of what we're going to do. Next slide, please. Attending, who's here, we're looking at the overview, the tactics in section 33. We've got 300 odd people registered for this, and at the moment we've got 180 people listening. So it's obviously a hot topic. I think it's a very necessary topic as well. Next slide. I'm just going to outline the different provisions that are there. You can see that the ordinary time limit for actions in tort is 6 years. And the important point of emphasis is that it shan't be brought after the expiration of 6 years, the date with the cause of action accrued. Section 5, 6 years for contract. But this is about clinical negligence and injury matters. Therefore, next slide. There is a special time limit. You may or may not be aware, of course you are, for actions in respect of personal injuries. Fatal accidents, I'll deal with those later. Negligence, nuisance, breach of duty. And for the damages, include damages in respect of personal injuries to the plaintiff or any person. Obviously, it could be somebody who might be proceeding by a litigation vendor or somebody else like that. None of the time limits in previous sections, the 6 years, apply to actions in respect of damages for personal injuries. Next slide, please. The period applicable is the key phrase. It's now 3 years for these damages being sought for personal injuries. And the dates are 3 years from the accrual of the cause of action, say when you got your leg smashed up in a car crash, or from the date of knowledge. That can be a time that actually you got your leg smashed up in the car crash, but you didn't know that the orthopaedic surgeon has completely botched the reconstruction until 18 months later. So it's whichever of those dates is the later date. Section 14 glosses that, and we'll go on to that in a minute, and Francesca will deal with that. There's other aspects. What happens if somebody dies before the expiration of these periods? What happens is that there's a claim remaining for the benefit of the estate, the Law Reform Miscellaneous Provisions Act 34, for general damages and associated sort of expenses. And that's 3 years from the date of death, or from the date of the personal representative knowledge, whatever's the later. So somebody may die, but the personal representative may not be aware that that person's death was because of a matter, a cause of action that accrued prior to that. The person's not aware until a later stage that there was a negligent heart operation or misprescription of medications until some time later. It's an interesting point of view. If there's more than one personal representative, which can happen, the date of knowledge is the earliest date. The dates of knowledge are different. So if two members of the family become personal representatives, the section 11.7 says that it's the earliest date of knowledge of whoever may be the one or more of the PRs. So that could be interesting situations. it's obviously going to be an evidential matter. PRs are sometimes destined, especially if they're family PRs, to fall out and have different recollections, but that's an evidential and factual matter that's specific to the particular circumstances, but it is the earliest one. Next slide, please. Other aspects, I haven't dealt with these here today. There are slightly niche, though I have been involved many years ago on the sort of metal on metal implants aspects of defective products and other aspects, but they're uncommon nowadays. And if you are so interested, go to section 11, the new section 11A, in respect of defective products. There's a new section 11B, actions against insurers of automated vehicles. Now, I think this is probably anticipating the future, when we're no longer the man on the Clapham omnibus, but the woman walking down Clapham High Street getting mowed down by some autonomous taxi or something similar, or maybe one of the delivery companies that no longer have drivers, but they just have people that load the vehicles and then you help yourself. Again, that's for the future. I wouldn't spend much time at the moment looking at those, but they're there just to flag up what they're about. Next slide, please. Fatal accidents. Now, there's a few catches in section 12 on the fatal accidents. I've highlighted them here. The first one is beware that under the Fatal Accidents Act, if the person could no longer maintain the cause of action because it's greater than 3 years from the day it accrued, the injury, or the later date of knowledge when the person knew that they'd suffered an attributable injury. If that has already passed, and then what happens is that somebody dies, that means that the cause of action had accrued, the time limit of 3 years had passed, and that if they die subsequently, then because of section 12.1 and section 12.2, no cause of action under the Act can be brought after that. The case of the cause of action is gone already. Look into 12.2. If there is a claim, and you can bring a claim under the Fatal Accident Act, when's the claim got to be brought from? It's got to be brought 3 years from the date of death is the longest point you've got, or the date of knowledge for the person whose benefit the action is brought, whichever is the later. So that would be, for example, a dependent. If there's a dependent and the dependent isn't aware that her father died from a negligent act and found out subsequently, and that's greater than 3 years, then if there is a date of knowledge point, that's fine, just as long as one can be clear about it, and it's a later matter. If there is no knowledge point and it's quite clear, then it's 3 years from the date of death. Section 31 will highlight in a minute. Next slide, please. If you just go back one, if you would, Francesca. What about section 28? Section 28, Limitation Act, that makes it clear. Sorry, if you just go back.
Sorry.
Don't worry.
This is not allowing me to go backwards. Here we are. Are we in the? Is this the right one?
Which one?
There.
Excellent. Yeah.
Sorry.
Section 28, and these are people under a disability. And a person under a disability, the most common things are people with mental injuries, be they physical or psychiatric, or children. Children are technically persons under disabilities, and they can not have the time limit running against them until they don't become a person under disability, i.e. 18 years of age, so that there's 3 years after that, so 18, often to 21 years of age. So that's the date, 18, when they cease to be a person under a disability. And that's just something just to bear in mind. It's something that I think most everybody's aware of nowadays, but I just emphasize where that's coming from. It's coming from section 28. Next slide, please. Other aspects of time limits and fatal accidents, another gnarly problem, is in relation to different dependents. So if there's more than one person, more than one dependent, an action is brought under the Act, then what happens is that the limitation is applied to each of them separately. And when you look at everybody separately, if it turns out that somebody has been a laggard and had knowledge beforehand. And a commonplace circumstance is sometimes when people are teenagers and they become dependents. At times they were children under 18, and as time goes on through the preparing the proceedings of such matters, they become adults, and that they are no longer a person under a disability. So if there are dependents and that one person arguably has become statute barred because they haven't done anything or that they knew about it beforehand, what the Act says, 13.2, is that that person should be excluded from the action. Next slide, please. The only thing is that that's qualified by 13.3, that the court won't give such direction if it's shown the action was brought exclusively for the benefit of the person. So this would be, for example, just a single dependent, a single child. And if the benefit wouldn't be defeated by defence of limitation because either they're a child, section 28, or unusual circumstances, such as an agreement between the parties not to raise the defence, or otherwise. Now, the or otherwise part of this is the bit that's challenging because it's not fully explained. Now, does or otherwise something that would defeat a defence of limitation? I can see how being a child or a person with a disability might, or an agreement between the parties not to take a defence of limitation. But does it include section 33? It's not clear on this, and this is an unusual circumstance. I would say that section 33 isn't designed to apply in these circumstances. This is something that really, you're under a disability, section 28, once that's alleviated because you become an adult, or there's an agreement between the parties, that can stop the limitation defence being raised. But anticipated that you might have a section 33 defence shouldn't. Next slide, please. Here we go. Francesca, it's your turn. On
Yes.
the hot stuff. The interesting part, after we do the basics, this is the date of knowledge. This is where all the prospects are, I would say.
Yes, I think you're probably right about that, David. There is just one question that's been asked in the Q&A, so can I ask you to have a look at that, David, while I talk about dates of knowledge? And also just to ask Audrey Serrano, you are raising your hand. I don't know if it is intentional, but I thought I would point it out just in case. If it is intentional, please do put a question in the chat or the Q&A. Thanks very much. So yes, on to dates of knowledge. Of course, we find everything about dates of knowledge in section 14 for the purposes of sections 11 and 12. And so subject to those subsections, dates of knowledge are the references to the date on which he first had knowledge of the following facts. But first, we look at subsections 1A and 1B, and I've set those out below. Defective products and electric vehicles, we've already discussed those, so I'm not going to dwell on it, but simply to flag up that those may become more relevant as time passes. The following facts are required in order to constitute the date of knowledge. The injury was significant. It was attributable in whole or in part to an act or omission which is alleged to constitute negligence, nuisance, or breach of duty. You must know who the defendant is or is likely to be. If it's alleged that the act or omission was that of a person other than the defendant, who was that person, and what additional facts support the bringing of an action against the defendant, the primary party to answer your claim. And then, of course, any other relevant knowledge. Just pausing for a moment on the significance of the injury. Section 14.2 says, for the purposes of this section, an injury is significant if the person whose date of knowledge is in question would reasonably have considered it sufficiently serious to justify his instituting proceedings for damages against a defendant who did not dispute liability and was able to satisfy a judgment. And the way to approach this formulation is in reverse order. So you have a defendant who would be able to satisfy a judgment because that's a legal personality. And if that personality did not dispute liability and the claimant would reasonably have considered it to be sufficiently serious and so significant, then you have the correct formulation. And what I've said is there's quite a low bar. If a claim would be an absolute slam dunk, would there be enough knowledge to want to bring a claim? Would you know that you had suffered a serious or significant injury? And if that is the case, you've satisfied the test and don't need to worry about it and you can proceed. But if you have serious doubt about any of those limbs, then carefully go through the test again and be sure about it. Because if you're a claimant and you get this wrong, you could end up in hot sauce. Section 14.3, the relevant knowledge test. For the purposes of this section, a person's knowledge includes knowledge which she might reasonably have been expected to acquire, A, from facts observable or ascertainable by her herself, or from facts ascertainable by her with the help of a medical or other appropriate expert advice, which it is reasonable for her to seek. But a person shall not be fixed under this subsection with knowledge of a fact ascertainable only with the help of expert advice, so long as she has taken all reasonable steps to obtain and where appropriate to act on that advice. So what does that mean? Knowledge includes knowledge which she might reasonably have been expected to acquire, includes knowledge, not exclusive, and knowledge reasonably have been expected to acquire from. So again, this is kind of muddying the water slightly. Reasonableness is always an alarming word, because what? Reasonable in all the circumstances? It's a subjective test. Always important to bear in mind the subjective nature of that. Expected to acquire, well, to what degree would you anticipate requiring expert evidence in circumstances where there is a degree of reasonableness, so on and so forth? And some of the cases that we're going to look at shortly deal with those aspects. Knowledge that you have acquired from facts observable or ascertainable by the claimant herself. So that's actual knowledge. My legs have been mashed up, I'm aware of that. My hand has been chopped off, I'm aware of that myself. So observable by her, just to make it completely obvious, is actual knowledge. Whereas knowledge that you acquire because you're told about it by an expert, that's different. And we've described that as constructive knowledge. So facts ascertainable by her, things you notice yourself, but then facts that you are certain about only because you've had assistance from a medical or other appropriate expert. There's a lot going on here, and it's really important to carefully consider the rules and then apply those to the factual matrix of your case, because again, getting it wrong can mean that you end up in a rather sticky situation. And it's important that where there's a lot going on, you take the time and care to unpack what the rules are and separate things out into an actual knowledge column, a constructive knowledge column, see what expert advice has been proffered at what point, and make sure that you've pinned it down so that if you're founding a cause of action and you're hard up against a limitation date, you can justify your date of knowledge, which a defendant will be aware of and will attack. And David and I have both advised both claimants and defendants who, you know, for whatever reason are issuing proceedings hard up against a limitation date, and there's a dispute arising because some aspect of this has been overlooked. The leading judgment remains that of the House of Lords in Hayward, which was a 2006 case, quite old now, I suppose, but really that is a useful and instructive bit of authority. It concerned financial advice rather than medical services, but the clear articulation of the relevant principles are of equal application and extremely useful to practitioners. The court examined the degree of knowledge required for time to run under Section 14, and most importantly, for the purposes of date of knowledge, the degree of certainty that a party must possess in order to get home on that date of knowledge argument should a dispute arise. As to the degree of certainty necessary to establish knowledge, Lord Nichols, who was endorsing, by the way, the approach of Lord Donaldson, then Master of the Rolls in Holford and Brooks, which, although an older authority, is also quite useful and sets out quite clearly the relevant rules. But in Hayward, Lord Nichols said at paragraph 9, knowledge does not mean knowing for certain and beyond possibility of contradiction. It means knowing with sufficient confidence to justify embarking on the preliminaries to the issue of a writ, such as submitting a claim to the proposed defendant, taking advice and collecting evidence. Suspicion, particularly if it is vague and unsupported, will indeed not be enough, but reasonable belief will normally suffice. In other words, the claimant must know enough for it to be reasonable to begin to investigate further. As to the question of the degree of detail required to have knowledge that the injury was attributable to an act or omission, Lord Nichols cited with approval the approach of a trial judge in a clinical negligence claim called Hendy and Milton Keynes Health Authority, an even older case, a 1992 case, in which the Judge Blofeld, said, "A plaintiff may have sufficient knowledge if she appreciates in general terms that her problem was capable of being attributed to the operation, even where the particular facts of what specifically went wrong or how or where precise error was made is not known to her." So you don't need to identify the precise mechanism of the alleged breach of duty. You just have to know that something has gone awry. To the same effect, Lord Justice Hoffman said in Broadley and Guy Clapham, Section 14(1)(b) requires that one should look at the way the plaintiff puts his case, to distill what he is complaining about, and asked whether he had, in broad terms, knowledge of the facts on which that complaint is based. So a summary of the date of knowledge under Section 14. The relevant date is the date on which the person first had knowledge that the injury in question was significant. The injury was or may have been attributable in whole or in part to the act or omission which is alleged to constitute the cause of action, and the identity of the defendant. So actual knowledge. If the negligence was that of a person other than the defendant, then the claimant has to know the identity of that person and to provide additional facts supporting the bringing of an action against the defendant. So, for example, we're talking about a doctor who was an employee of a hospital trust. It's the most obvious example. Note that knowledge of any acts or omissions did or did not, as a matter of law, involve negligence is irrelevant. Whether the injury is significant is subjective. So again, we're back to the actual knowledge versus the constructive knowledge. And I've set it out again there, just so that you are absolutely clear about it. Recent case law, I'm going to hand over to David in a moment, but I wanted first to talk about a case that I was recently instructed in because it concerns a date of knowledge argument. And I think it's helpful always to think about these things, not just on the basis of the black letter law, but also taking a more pragmatic and tactical approach. So I was recently asked to advise about the merits of striking out a claim on the basis that limitation had passed because there was a clear date of knowledge and limitation must run from that date. And the case concerned a claimant who had not been informed that he had blood test results indicative of pre-diabetes. And he went on to develop frank diabetes, and his case was that if he'd been told about the original results, the missed results, he would have averted that outcome because he would have taken immediate action to prevent the development of type 2 diabetes. And what we have are medical records which show that at a GP appointment, the claimant was informed about the missed blood result. He was told that he'd developed frank type 2 diabetes. He was shocked. He was upset. He demanded that there was an investigation into how the original blood results had been missed. He wanted an explanation. He was offered an apology by the GP. And so what the defendant said was, well, this is his date of knowledge. He knows something has gone wrong. He knows that it's significant because he's gone on to develop diabetes. He knows who is responsible. And therefore, time starts running from that date. And yet, we have proceedings that are issued 10 days over the time limit that ensued. And so what should my advice be? Is that material ripe for a strikeout, or should we incur the costs and risk of doing that, or ought we plead limitation in the defence and ask the court to consider whether it would be appropriate for there to be a trial of a preliminary issue on it? And my advice was that strikeout was high risk because 10 days too late is late, but not an insane delay that has prejudiced anybody. And if you make a strikeout application on that basis, you're going to be faced with a cross application for an extension of time under Section 33 akin to relief from sanction. And of course, David's already flagged up that we're going to do another webinar on Section 33 applications quite soon. So I said, too high risk to make a strikeout application at this point. You'd probably end up with the possibility of a costs award against us. It's not sufficient, but it ought to be, of course, raised and pleaded in the defence. And if the court considers that there ought to be a trial of a preliminary issue, then that's the way to handle it. So you can see there that one must always take a pragmatic and commercial approach to even a clear case, I would have thought, where date of knowledge had led to the proceedings being issued too late. I'm going to hand over now to David, who's going to take you through some of the other interesting and useful, informative cases on date of knowledge, and I will move on to look at any other questions in the chat or the question and answer box. So David, handing back over to you.
Thank you, Francesca. I've set out just some relevant cases that underline some matters. I have to say that one of the things they do underline, and again, we'll be dealing with this in due course, is the potency of Section 33 in the hands of claimants. But here's some that focus upon especially Sections 11, 12 and 14. Bowles and Reeve, this is a man who'd worked with asbestos for many years. I haven't included the full depth of the facts, but I will, just because I was thinking about this and I thought bring it a bit more, I wouldn't say to life because the poor man was poorly, but something different. The claimant in this case was 81 years of age. He worked as a carpenter in the defendants business from 1954 to 84, during which time he regularly worked with asbestos, generating large amounts of asbestos dust without any protective equipment. Many years later, developed respiratory problems, and then later still, December 2016, 2017, he had a persistent cough and breathing difficulties, so his condition significantly deteriorated in 2016-17. GP referred him for a scan, and that in May 2017, he was diagnosed with asbestosis. That's a notifiable disease, and it means that there's been very significant lung damage. All be aware of the fact that asbestos causes responses of silicosis, where your body cells can't munch up the sharp asbestos fibres and produces chronic inflammation. It can also lead to mesothelioma. So somebody said to him that he might be entitled to some compensation. He went and instructed his solicitors and got some medical evidence and filed his claim against the employer's estate. He subsequently died, the employer, in 2019. What happened was that the defendant said that the claim was time barred under Section 1114 because the claimant had known about asbestos-related damage to his health as far back as the early 2000s. He knew that he had some respiratory problems. They just were nowhere near as severe as they subsequently became. He'd also had an X-ray taken in 2013 that mentioned about potential exposure to asbestos, but didn't make a diagnosis of asbestosis. The claimant said, no, I don't acknowledge that the injury was sufficiently serious to bring a claim in 2017 when he was diagnosed with asbestosis after that severe deterioration in his condition, his respiratory condition, in 2016 and 17. As you can see, the court found in the end that it was appropriate that C wasn't fixed with constructive knowledge under Section 14 because his respiratory illness prior to 2016 was mild and insidious. Next slide, please. And the court in its judgment, it's instructive looking at it, it sets out aspects of the steps that have to be followed in these cases. It's well structured. We get limitation, actual knowledge, and then constructive knowledge. He didn't have actual knowledge within the meaning of Section 14 of a significant injury attributable to exposure to the noxious agent asbestos here. Diagnosed with asbestos 2017. He accepted the respiratory problems, but he considered they weren't sufficiently serious enough to bring them to attention of his GP or hospital doctors. And actually, when they did bring it to his GP's attention, when he had the X-ray in 2013, they didn't think very much of it. And they decided that it was something not to to investigate further, and it wasn't until his serious deterioration, 16, 17, that anything was mentioned. Constructive knowledge. So, okay, well, he didn't think it was very serious. It was insidious, and it wasn't until 16, 17 things were bad. The court decided that the claimant should not be fixed with constructive knowledge. His injury was significant prior to the asbestos diagnosis in 2017. They drew a distinction between the minor aspects, signs of asbestos, and the 2017 definite diagnosis of asbestosis. Exposure to asbestos can be harmless, and what 2016-17 actually brought was a discrete asbestos-related disease. He did say that he'd had his problems for years, but the court, giving a fairly sympathetic ear, I think, for a man who obviously was unwell, decided that it wasn't notable, something that fixed him with constructive knowledge. Nobody else thought that it was sufficient. Now, in one sense, what the stress and the level of diagnosis that the hospital doctors or his GP might put upon it should only be a minor factor. It should really be, does the claimant think, or should he ought to be thinking, that he has suffered injury? It's not really the extent of the injury, as long as it's sufficient and some injury. Behind all this, I think the real reason for the court deciding this is not that it's sympathetic ear, but decisions about what was a sufficient knowledge about the injury. Was it something that would really make you think, oh yes, that this is an injury and is a problem? I'm a bit perplexed, because I would have thought that most people looking at this themselves, if it were to be your standard Christmas quiz, would say, yes, he probably did have constructive knowledge, but there we are. Next slide, please, Francesca. The other point being, and this is all part and parcel of the eventual reasoning that you do see from courts, they don't hermetically seal Section 11 and Section 14 matters. Under Section 33, the court gilded this by saying, well, essentially, even if they were wrong in that, the Section 11, Section 14 point, they would have permitted the case to continue under Section 33, because it's unjust to deprive the claimant of the opportunity to pursue a claim. No serious prejudice to the defendants. There we are. Now, Mr. Pardon my West African, but Mr. Adorunmu, I think that's how you pronounce it. This is a man who had previously had a consultation with his GP, difficulty talking, further tests, and he later suffered a stroke which caused neurological injury. He subsequently brought a clinical negligence claim against the GP, but in the interim, after the consultation in 2011, he'd been fixated upon applying for a leave to remain in the UK, and these immigration proceedings were focused upon until a later stage those were sorted out, and it wasn't really until the January of 2017, so we're looking at 8 years after the consultation with the GP, and a smaller number of years after he'd been involved in the immigration proceedings, that he contacted solicitors about a possible clinical negligence claim. And this was, if we could just have the next slide, please, and that's probably the best place to go. What happened is that he claimed that the 3-year limitation period had not started to run because since the date of the actual course of action, he lacked the capacity to conduct the litigation within the Mental Capacity Act. We'll see, I'll explain in a minute, he got short shrift from Master Cook on that. He advanced the secondary position that if he's found to have capacity, he didn't have the requisite knowledge for the purpose of Section 14 for a date more than 3 years prior to the October of 2017. And then Section 33 thought. He's essentially claiming, and the one that was given the greatest amount of consideration, was that because of the details and the complexities of the neurological injury he allegedly suffered, and the fact that he hadn't got any expert advice from a GP expert, that he wasn't fixed with knowledge prior to the 3 years prior to the October of 2017. I've not included, but I've decided that I will mention this and read it out because I think it's important. The parties served expert psychiatric and neuropsychiatric evidence. The experts agreed or disagreed on the extent to which his impairment affected his ability to use or weigh information as part of the process of decision making. Neuropsychiatrist disagreed whether the claimant's impairment affected his ability to understand information relevant to his case and retain information. So your ability to make decisions, capacity to run your proceedings, the capacity to make an actual Section 14 decision that you had a cause of action and you'd suffered injuries, you clearly had a stroke. Master Cook decided the preliminary issue in favour of C. As to his capacity to litigate, when considering capacity, the court was not bound by the expert evidence alone. So Master Cook stepped back from that and said, you might have psychiatrists and neuropsychiatrists, but I'm going to take a view on this myself, which he can do, Cook. He's quite robust at times. The court was not bound by the expert evidence alone. It could take into account all the available evidence, so he could deal with the issues and make decisions in his litigation. He was able to give instructions. Cook decided there was no evidence for any deterioration of conditions since that time. He found that he did have capacity to litigate, and he had capacity to litigate at all material times. So if that had been it, Cook would have said, no, you had capacity. The evidence for everything is that when you'd had the stroke, it didn't destroy your capacity, and your capacity hadn't otherwise been altered while you were conducting your immigration proceedings. And then what comes out? Data Knowledge Limitation Act, the clinical records indicate that he knew in December 2010 that his injury was significant. He knew his injury was attributable to the omission by the GP, and it was probably a breach of duty. Therefore, he had actual or constructive knowledge for the purpose of Section 14 by no later than 20th of December 2010. So you thought, right, that's it, he's not going to proceed. After Section 33, Master Cook found the delay in C contacting solicitors concerning alleged political negligence in January 2017 was explained by the fact that C required appropriate help and support to make relevant decisions. He'd been preoccupied with conducting his immigration litigation. The clinical records in 2019 were available. Defendant GP had an independent recollection of the consultation. Therefore, considering all the circumstances and balancing the prejudice to C and D, the balance fell in favour of C. Possible to have a fair trial, equitable to allow under Section 33 the action to proceed. So, Section 14, you've got the knowledge, but I'm going to let it through on Section 33 in all the circumstances. As you see from this, these curious cases sometimes make what I think is bad law, but one wonders what a defendant has to do to succeed on a Section 14 when Section 33 can be deployed in this way. It also, I mean, these cases, there is an element of judicial sympathy, and there must be, because of what he was having to face with the immigration matters for somebody that obviously did have some problems. So it's difficult to be disparaging now. There are obviously more nuances to this, but it's a clear indication at a move that the Section 14 perhaps doesn't have the force that it might otherwise have. Moving on to the next one, we've got Wilkins and University Trust. We'll just go back to a bit. There we go. Preliminary issue and limitation, the claimant to have knowledge for the purposes of Section 1114. He did not need to appreciate all the details of the claim that he might later formulate against the defendant from the time to begin. He was not required to know there had been an actionable breach. It was sufficient that he understood in general terms the essence of the factual case upon which the later claim might be based. So it's in general terms. What general terms means is subjective, I submit, and depends on the circumstances of each particular case. Next page, please. And it went on to clarify, in a clinical negligence claim, it was not necessary that the claimant appreciate the precise mechanism by which he sustained an injury. Sufficient if you're understanding in broad terms that the lacking medical care might be a possible cause of the injury. So this is pretty widely drawn. By June 2012, in the Wilkins case, he was in broad terms describing his ongoing knee pain to treatment he received from the defendant's staff. This was about a surgical technique for a knee replacement. He developed some swelling afterwards that was thought to be due to perhaps a post-operative infection. That seems to settle down. And it was only at a later stage that it became apparent that there were problems with this knee. The court decided at the end of the second paragraph, broad knowledge for Section 11. By June 2012, he had the requisite knowledge that the claim was brought at 7 years after the time began to run and 4 years after it was statute barred. Now, guess what? Exercise of discretion under Section 33 to permit the claim to proceed, decided it was equitable in all the circumstances to justify the time limit and permit it to proceed. Next, please, next page. So, where are we with these matters? Well, we've considered Section 1114, we've outlined the law. We can understand there's a mix of subjective and object matters, actual and constructive knowledge. So the case law is instructive, if only just to highlight exactly what some of the problems may well be, and how you may be able to succeed with a Section 11 or 14 if you're a claimant, or even rebut it if you're a defendant, but there's still Section 33 comes into play. Next page, please. What I've done, as well as considering where we are about the next seminar and things like that, I've decided that I would bring a summary or form a summary of what my conclusions were, and I'll press them out to you. We've got 15 minutes left, and part of it is what can we bring from this for claimants and defendants. First set of tranche of conclusions. Section 33 in the background, defendants' escape route to present. So you've got to understand the mix of objective and subjective knowledge required to form a data of knowledge if relevant. What claimants ought to ensure they do, this is my view, advice to claimants, an early record of the evidence of data of knowledge, ensure the letter of claim and an early draft witness statement of fact, and in time the particulars of claim are accurate and consistent. That way, that will decrease the efflux of time, the fact that time passes, and make it less of an impediment, because the defendants are going to say, memories fade, we don't have compendious records, if any, that are appropriate to perhaps data of knowledge, and that those are matters that are affecting our ability to defend these claims. So from a claimant's point of view, early record of evidence on the date of knowledge, letter of claim, draft witness statement. Don't be complacent and passive just because Section 33 at the moment is on a bit of a crest of a wave and there's been a number of sympathetic judgments in favour of claimants. These things change, and you can't rely upon that to continue on. It would only take a couple of High Court cases where actually the judge was perhaps less sympathetic than they have been historically for that to change. Next.
Sorry to interrupt, David, but can I just, because a question was asked in the chat about this, about whether the courts have sympathy for claimants who may have suffered quite horrible injuries but who bring late claims. And what I said in response was that sympathy is not something which ought to really factor. The courts will have regard to the circumstances of the case, and when making a judgment in all the circumstances, so in the context of a Section 33 application, sympathy may well be mandated, but it shouldn't and it ought not to be the decisive factor. I don't know whether you agree with me on that, David, but I would have thought that courts are prepared to strike out even good claims from claimants who are utterly deserving of sympathy if they haven't for some reason complied with the rules.
I think it's probably less black and white than that, because sympathy, it isn't just, oh, there's somebody that's badly injured, I'll try my best and ensure that they get enough to make some difference for the rest of their challenging life. Sympathy, I think, is got to be looked at through the lens of, for example, the factual evidence and the recollection of the factual evidence. Somebody that may well be badly injured is often consciously or subconsciously, in effect, given some leeway, and in a greater extent than others, by certain judges and not other judges, or even the approach taken by the Supreme Court seems to be quite sympathetic at times. And it's not just as simple as, yes, that's a very injured person. It's looking at the evidence and the recollection. I'm prepared to accept their evidence, etc., etc. And it permeates through to the building blocks of the claim that's being made against a defendant. And that's the challenge that a defendant's got. These are just matters of real life. And the idea that the court will ever express it in that way is probably naive. But what the court does do is look to the evidence of fact and those such matters, and that influences things. So that's my view. I'm quite pragmatic. when I say a sympathetic hearing, the point about it is the sympathetic hearing of the evidence rather than the sympathy voiced on the claimant. Coming back to where we were, I just explained my view about what claimants can do, and don't be complacent because of the way things are going in Section 33 doesn't necessarily mean it'll continue on. So, what can the defendants do? What would I say that the defendants could try to do to improve their limitation stances? My view is that the defendants have got to get across their evidence earlier. One sees it again and again that the evidential harvesting has been left very late. Nobody's spoken to the treating staff. Sometimes it's because of the pressure of work. It's often because of the pressure of work in the legal department in any particular trust or with the defence and support organisations. But the defendants have to get across their evidence early. If they think there's a limitation defence, it's not enough just to rely on traversing it in the defence at the formal pleading. You've got to look to the evidence from treating staff concerning actual and constructive knowledge. So there's got to be strong early review. With that, a considered letter of response that makes the points on actual and constructive knowledge. Now, I know it's busy, resources and other things like that, but if you're going to improve your circumstance and you're going to try and succeed with Section 11, 14, and for that matter, the various aspects of discretion in Section 33, they all feed into each other a bit, then defendants, in my view, have to get across this evidence earlier. So what are the other points? There's just another few little ones. Matter of law, alert to time limits from an early stage. That goes for both claimants and defendants. Try and get to grips with the understanding that the mix of objective and subjective knowledge to acquire, to form a date of knowledge, and think that through, and seek to get the evidence at an early stage, either from the claimant or their family or whoever, or if you're the defendant, from the treating staff. The case law is instructive, if only just to show the points that are focused upon. And it also is instructive, as I mentioned, coming right back to the end of it, the Section 33 aspect, and we'll deal with that in detail in the next webinar. It's also addressed in the webinar supportive details from the briefing and the documents that supported that briefing that are referenced at the start of this presentation. Here we are, as far as the next thing, that's the end of the focus advice that I can give. I don't know if Francesca's got anything further that you want to add in.
No, other than to say that both of our email addresses are on your screens. So if you do have any questions, or if something occurs to you whilst you're having your inevitable pre-1 o'clock cup of tea, just pop us an email and we'll always do our best to help. Of course, there is going to be another webinar next week. It is Sarah Prager and Ian Clark talking about data protection made easy, the fun side of data processing.
Well, Sarah is probably the only person I know that will make data protection.
I was just about to say, like, I'm really struggling a little here, but of course we've also got the Supreme Court handing down its decision in Lloyd and Google next week, which I think will make this a webinar you don't want to miss. Any questions, any thoughts, don't hesitate, let us know. Thank you so much for tuning in and have a lovely rest of the day.